Thank you very much for inviting me. It's always a pleasure to address this topic. It's the first opportunity I've had really to talk about it since it was proposed, and this really has been gestating for 8 years or so until we finally got to this point. So what actually do we have? How do we assess it, particularly from a human rights point of view? There's many different aspects you could assess it from. I wanted to write something in detail about children, for instance, under the Pact, but haven't yet had an opportunity. Many other examples of angles you could take. But this is an overview. There are highlights or lowlights, if you like. What are the main issues? What are the main human rights concerns? Now, this is a summary of a paper I've written, forthcoming in the Yearbook of European Law, of about 49,000 words. Even with its length, it does leave out some of the fine details. And obviously, given the amount of time I have today, I'll have to leave out a few more. There's quite a few slides, and I'll have to be skipping through them, I think, and extracting just the highlights. So there should be an open access version of that coming. The organisers will organise the availability of the full slides as well. And as David pointed out, I have effectively extracted the parts of this paper anyway in a series of blog posts. So if you haven't seen those, but 8 blog posts on different aspects of the Pact, which are very similar to the final paper. But that will be an academic paper with more detail, with 700 footnotes. If you want to indulge your fetish for footnotes, you'll be able to. Okay, so the background, I assume most of you are familiar with this. We had the Dublin Convention, we had some soft law, we had a kind of first phase of the common European asylum system with various directives on qualification procedures, temporary protection, reception, and Dublin and Eurodac, Dublin II, Eurodac regulations. We then had a second phase, most of those replaced by new directives and regulations, plus a regulation on European asylum offers all around 2013. But before long it was perceived that this was a problem, wasn't, from a member states' point of view, politically sufficient to deal with the numbers of people who started to come in, particularly Syria, Afghanistan, Eritrea, many other places as well, over 2015 to 17 in particular. So we had these, you may know, short-term emergency relocation decisions. There's an emergency power that the EU can use. Use it for the first time, only time so far, to got 2 decisions on relocation, but they have to be temporary, they expired, and they weren't really properly applied anyway. The idea was to move 160,000 people from Italy and Greece to other member states. The other member states got cold feet really about transferring most of those people, and they never were relocated. So what do we have in terms of the Pact? Well, it's called the Pact officially, but legally speaking, this is mostly binding law, although of course binding is a relative term when it comes to asylum law, probably anywhere, but certainly in the EU. We know lots of examples of pushbacks, which are illegal, and other actions of member states which are illegal. When I write about officially this is the law, I'm aware that it won't necessarily be complied with any more than the existing law is necessarily complied with in parallel fields as well, like State Borders Code of rules are clearly not complied with it. Every year the Commission compiles a report on Schengen, and every year a bunch of member states have continued their controls on internal borders. But we know from the legislation and the case law, they can only do that for 3 months. But they keep on doing it year after year. The same thing may, of course, happen here. And it's not just the EU member states implementation. It's the practice of the Commission that the other institutions may be rather questionable as well. So anyway, but the starting point is we have this legislation. It is meant to be binding, all published on the 22nd of May, mostly replacing existing texts. In 2 prominent cases, replacing directives with regulations, which mean they're In principle, the law of the land without national implementation. Some other changes, of course, I'll come to. But in addition to that, qualification and procedures laws, we have a revised reception conditions directive on how to treat asylum seekers. We have a special law on a returns border procedure. We have new legislation on resettlement and screening of migrants and crisis situations. And we have revised legislation on Dublin and Eurodac. All of that together has done quite a lot. Some have changed the law more than others, but there are quite comprehensive changes. As I say, I can only extract some of the key details in the time available. So most of this applies, and we know the exact date now. It's been published from either June the 12th or July the 1st of 2026. In one case, it's a real botch. The qualification regulation says applications are governed by the qualification directive up to June the 12th, 2026. Applications made after July the 1st, 2026 are subject to the qualification regulation. Well, of course, what happens to the 3 weeks in between? And that's kind of, unidentified legal object during that period. But presumably that's an error they'll fix. There's lots of other glitches, I think, in the way this legislation is drafted up. I'll mention a couple. Having said, we have to wait till 2026, some stuff applies earlier. As we'll see, I'll talk about some implementing measures, preparatory measures, which have to be adopted earlier, and the resettlement regulation, because that money's already being spent. They don't wait to 2026. That regulation applies next week, so from June the 12th of 2024. But this may not be the end, though. Having said, some people on the centre-left of the European Parliament having thought, we'll do this deal and the people on the right will stop asking for asylum law. Well, they're not going to stop asking for asylum law. A group of 12 member states have already written a letter saying the next European Parliament, the next Commission, should do a lot more restrictive stuff as soon as possible. So that may well be acted upon. And one question we'll see about the European Parliament about to be elected this weekend and the European Commission to be appointed afterwards is how much of that they take on board. Because the assumption is the Parliament will move significantly to the right. And this could well be a factor in who gets to be in the Commission and what they promise to do to satisfy those member states and to satisfy those members of the European Parliament who will take these more restrictive views on asylum. We are going to be, I think, very imminently in a different political scenario than what we're used to in the EU, because the Parliament has always been a kind of moderately liberal break. I mean, not as liberal as radical as some people would like it to be, but certainly not as amenable to restrictive measures as many member states would have liked it to be. It has been sort of standing the way. It's probably no longer going to be standing in the way. It may be facilitating, encouraging, pushing for. It may be a factor on the completely opposite side of the argument. And of course, as I said, that may affect the Commission. Even if the current Commission President doesn't get back in, well, whoever is the Commission President instead is going to be making pledges to these MEPs, these member states, on these issues. And even if it's Mr. Draghi, who's a technocrat, he's going to be focusing on economic issues, the person in charge of migration might well be some, Hungarian headbanger, as the Migration Commissioner in the next Parliament, strongly influenced by member states with a similar point of view. All right, I'll say a little bit about territorial scope. There's some interesting questions about Ireland, which opted into some of the earlier legislation. The government says it will opt into at least 3 of the measures under the current Pact. So we haven't seen the official letter, so the process hasn't been gone through officially to opt in. So it may be that they want to opt into more, but they certainly want to opt into procedures, Dublin and Eurodac. So that will have an impact, in fact, on their relations with the UK, as well as, of course, the rest of the world. Denmark, the Schengen Associates, mostly don't apply EU law. They do apply Dublin, Eurodac, and part of the new pact actually links back to Schengen, screening of migrants and return borders procedure, so they will be applying that. Now, I'll focus on the recently adopted legislation, but there is a broader context of other stuff that's still out there. So the Temporary Protection Directive, they wanted to get rid of it, it still survives, still enforced, unamended, out there. So they can use it, they probably won't unless people look like Ukrainians in the future, but they could still use it in the future for future crises. The Returns Directive also still out there. The attempt to amend it, Parliament had locked for 6 years now, but of course the next Parliament might not. And the European Commission's already talked about maybe rethinking this and having something very closely related to an amendment to the Returns Directive, obviously much more restrictive and more closely related to the new asylum legislation. There's already loads of crossovers without even amending it between the new legislation and the Returns Directive. The Schengen Borders Code, they have also amended separately, and that's relevant to asylum, particularly because the recent amendment, which will apply in July, so earlier than most of the asylum law, has some stuff there on instrumentalization of asylum seekers across the external borders as well as fast returns between member states, although that's not meant to apply to asylum seekers. Obviously, we'll see what that really means in practice. It could be someone crossing from Poland into Germany. Germany wants to return to Poland. The person says, well, I'd really like to apply for asylum, and then the German border guard says, I'm sorry, I didn't hear you. It's 24 hours, no suspensive appeal, and you're back in Poland. So we'll see how that works out in practice. Okay, now, the asylum legislation itself also amends some other laws. It amends some EU laws on funding. It amends some EU laws on databases. It amends the capacity to be a long-term resident of the EU. Slightly easier for an asylum seeker, but somewhat harder if you break the Dublin rules. If you go to a member state that you're not meant to be in, the clock's reset on getting long-term resident status. But that's the mildest thing they do to people, to sanction people who break the Dublin rules, as we'll see. There's quite a few other things happening to them as well. Now, other proposals are on the table. As I mentioned, the Returns Directive proposals are already out there. There's proposals on the Long-Term Residence Directive on linking readmission to trade preferences, on instrumentalization separate from what's already been agreed. They could, of course, come back to all these after the European Parliament election with MEPs who are more willing to agree to more restrictive approaches than the outgoing Parliament. We don't, but that's a real possibility. Now, in terms of implementation, we're going to have a lot of stuff to look at. At the moment, we only have the legislation to look at, but before long, we'll start to have implementing measures even before those application dates in the middle of 2026. So the Council can adopt a 2-year resettlement plan, presumably do that soon, because that's a regulation will apply next week. The Council will adopt a solidarity pool. We'll look at that shortly, as to assisting member states under the Dublin system. The Council can adopt rules on applying crisis exceptions for member states. And the Commission will do a bunch of stuff. Some of that's already there. A lot of it's new. What we'll see imminently from the Commission next week is a common implementation plan on this legislation. There might be some proposals at the same time, but there has to be a common implementation plan within 3 months. They brought it forward, presumably to avoid the Hungarian presidency at the end of June, which will come in and says it wants to stop the Pact. Well, you can't stop the Pact. It goes mostly in the Hungarian direction anyway. But you can't stop the Pact. You can try and avoid the Hungarian presidency by having this discussion a couple of weeks before it comes in and tries to complicate things. So we'll see what it actually does when it is in power. There's a limit to what council presidencies can do. In fact, they amended the council rules of procedure back in the 1980s to deal with rogue presidencies. Someone must have sent back a terminator to tell them all bans coming in the future. So they have already dealt with that possibility. We'll see if that has to be used, of course. But in general, and I can't go through every detail of this, but in many, many ways, a lot of the individual rules on different asylum issues, not just qualification, procedures, other issues as well, are more detailed. In addition, I already mentioned 2 of the directives are placed by regulations. That means inherently more harmonization. But in those 2 directives, they used to set minimum standards on the procedural rights and qualification for refugees. That's gone. They no longer set minimum standards. It's now harmonized. Now, minimum standards anyway qualified. There was a kind of ceiling. You had to be compatible with the directive. You had higher standards. That it's relevant now because this is harmonization. It's full harmonization, unless there's a few cases left where things are optional for member states. Nowhere near as many as there were before. Now, reception conditions is still a directive. It still has that minimum standards clause. Temporary protection is still a directive, minimum standards. And you can still have national protection outside the scope of EU protection, as the case law said before. That's confirmed. So you can say that, you're Germany, you want to protect this person, but it's a national form of protection. You can't call them a refugee or a person with subsidiary protection. Right, so I'll skim through what are the main elements, because I do want to leave time for questions. The screening regulation. There's going to be almost everybody, this is one of the new regulations, almost everybody, not quite everybody, nearly everybody who either tries to cross or is found crossing, having previously crossed without authorization, is going to be publicly detained and screened for up to a week to gather information from them and to filter them into either an asylum or return process. Now, people get this a bit confused with the borders procedure, which is a longer thing where the decision is meant to be made. I'll come to that. This is only a 1 week period. Decisions not meant to be made within that week. That would be an incredibly short period. Not meant to be made during that week. You're just meant to filter someone, get do security checks and so on of the individual. So I won't go into all of it. There is meant to be a human rights monitoring process for both the screening regulation and borders procedure. This applies as well. Independent human rights monitoring process. The Parliament was very big on this. It wanted it to apply to pushbacks. It won't. But it will apply to screening and border procedures. The Parliament put a lot of store by this, saying that there's no actual legal rights for the asylum seekers in the screening regulation. So this is a replacement for that during that screening process. I wonder, though, if you look at Frontex, for example, which has for many years had an independent human rights monitor, if you look at the actions of Frontex over the last few years, you might well ask yourself, well, how much impact has the independent human rights monitor has on the behavior of Frontex? I think the previous executive director, some of his emails even insulted and denigrated people doing this task. So one would hope that it has an impact, but might wonder if it does. Right, then the resettlement regulation, also the other route that deals specifically with the entry process. As I say, there's already some soft law on this, there's already some EU funding, this will apply fairly quickly. The way it's drafted, though, it tries to exclude individual rights, like the screening regulation, as much as possible. It says there's no right to be admitted or even to request being admitted. There's no obligation to admit. The member states' commitments are purely voluntary. The whole process of meeting and having pledges and so on. I'm more familiar with in various forms from the international resettlement over the years, but it's an EU-focused version of it. But all of this will be voluntary. So it's quite hard to see how any of this goes to court, really, given that it's voluntary, no rights for individuals and so on. So very nice setting out the details of how this will work, and it does clarify if you'll be settled in the normal route, you are fully treated as a refugee or a person with subsidiary protection. Via the other routes, you might at least have the same rights as them. So that might be something to litigate about once you're on the territory with that status, and it's being withdrawn, for instance. You could challenge that, the same as anyone else facing a withdrawal. But quite hard to get in, to use the legislation to get in the first place. Okay, I'll skip over a bit of the details there. Right, let's move to Dublin. Now, Dublin has always, just now the RAM, well, I'll just call it Dublin, especially I am locked in, so it's weird if it were, you will. It's still going to do what it's always done. As a starting point, who is responsible for the application, which single member state is responsible for the application, and how do you give effect to that? How do you transfer someone to the responsible state? What are the procedural rights to challenge transfers and so on. That's all still there revised, but it also has two new sections connected to each other. There's an overall framework for migration management, and there's a solidarity mechanism because a permanent solidarity mechanism, not the ad hoc version we had 2 years, that shares the burden of applications as the legislation and the EU treaties put it. Okay, so first of all, what happens to what we have already, the responsibility rules? So we have the same basic idea, a list of responsibility rules. There's a new one about security checks. If you do a security check, which you must do under screening, and if the person fails, well, you're too bad responsible for that application. You can't in any way send them somewhere else. There are human rights exceptions in the original case law and the legislation. They're still there, they're slightly revised, but the same basic idea is retained, that you can have a human rights exception if a member state is totally failing, or at least for some categories, to deal with the asylum process. It's now explicit, it was always kind of understood and applied in practice, that asylum seekers have to apply in a state of first entry, or which gave them a residence permit. That's now explicit. And it's not just the formality of making it explicit, there are sanctions if you don't stick to that rule. So what are those sanctions? How can you be punished? Well, overturning the case law on a number of points, you can lose reception conditions, so you can lose benefits. If you're meant to be in Germany, but you've gone on to France, France manages to apply the Dublin rules, tells you you're responsible, you should be in Germany, we're going to transfer you, and at that point France can cut off most benefits, not quite all as we'll see, but there still has to be a basic standard of living. The benefits may be so low already, and how much lower can they go? But in principle, they can go low. You can also be cut off from access to employment, which you sometimes would get under reception conditions rules. And of course, we'll come to detention. That may well be one way of type of indirect punishment for non-compliance as well. Now, the drafting of this is terrible, because the Dublin regulation, but not the receptions regulation, contains some exceptions, some quite significant ones. You can't apply the sanctions if there's reasonable grounds to believe the person is a victim of human trafficking. So very important for anyone who deals with trafficking cases. Quite a few asylum lawyers, of course, do have some trafficking cases. It's already been based on Dublin trafficking. It becomes more important because you can't be sanctioned. And that directive has just been amended as well. So look at that amendment to see what some additional possibilities might be to say the person is a victim of trafficking. They must also take into account human rights circumstances, whatever that means. It's a bit vague. But so there are some significant exceptions to that prospect of punishment. However, leaving that aside, how have they changed the grounds to determine which member state's responsible? They've widened the family grounds a little bit. They have longer periods if you've had a residence permit or visa for still being responsible. The member state that gave you that. There's a fun new ground for academics. If you've got a diploma, if the asylum seeker got a diploma, the member state that gave her the diploma is responsible for the next 6 years. So it's quite exciting when we're deciding on the borderline when we're marking whether someone passes or not. How you can determine if that member state will be responsible for the next 6 years. Were they to apply for asylum in that member state? I'm not in that state. But for those who are, very exciting. They've also fiddled with the main criteria, not the only criteria, the main one on irregular entry. It applies for a longer period, for example. There's a special rule on search and rescue. Various search and rescue clauses have been added to the rules. It's the Malta, particularly. You've seen those on that. They changed the procedural rights. Now, crucially here, they have cut back on the effective remedies for asylum seekers. The legislation, the previous case law said there are loads of cases where you could challenge whether member states have correctly applied the criteria. The Dublin has been amended to say, no, there's only a handful of cases where you can challenge a member state. Otherwise, they can do what they like. I mean, remedies don't even come into it. You can't even challenge it, except in the cases where the EU court has already mentioned the EU Charter, So I mentioned Article 4, that's the non-refoulement, serious problem in another member state ground. Decisive circumstances since the transfer decision, infringement of the family laws. You can argue those because the court has mentioned the Charter. There's a load of other grounds which you could argue before, but the case law has let you argue them, but you can't under the new regulation because the court didn't happen to mention the Charter, so they think they can get away with not letting you challenge a transfer decision on member states allegedly getting it wrong on any of those other grounds. Now, there are also time limits. This is the first example of a lot of what the new Pact does. It brings in time limits for a load of things to a degree of harmonization, not always full harmonization. You can see there's a range here, but member states must give people between 1 to 3 weeks to bring an appeal. Of course, they won't always be able to bring one. But for those who are still able to bring one, you have a period of 1 to 3 weeks. Member states can't be more generous than 3 weeks. 1 week is fairly ungenerous, obviously, as a possibility to bring an appeal. And there's no longer really much of a prospect of getting suspensive effect, even of those who can still challenge a transfer decision. That's no longer one of the possibilities. It's now a request to the court for suspensive effect. You might be removed to another member state, and your main application in the other member state might be dealt with even before your appeal against being transferred there. It's the way that these things have now been drawn. Detention, yes, well, you can't be detained just because you're subject to a Dublin process. I'm sure you would love to do that, but you can't. But they have lowered the threshold to detain you in the Dublin system. So it's no longer a significant risk of absconding, it's just a risk of absconding. And that's not further defined much. And there's a new second ground, a national security public order ground. There are rights to challenge your detention and so on, and a few vague safeguards that still remain. There are some time limits built in because the Dublin process itself is subject to time limits. So this is one area where detention is time limited, but then you're going to another member state which may well say you must have a risk of absconding there because you've already gone to another country. Well, that's an obvious risk of absconding, then they can detain you as well, and then you have another problem. But within the Dublin process as such, there are time limits. The transfer process as well, lots of points there amended, lots of longer possibilities to keep member states responsible in that context as well, but shorter deadlines to move these people to do the transfers as well. One important point, I think, which is very suspect from a human rights point of view, is I think, it's badly drafted, but I think they have got rid of the existing rule, which says if you go from one member state to another, if Greece is the responsible member state, you go and apply. Germany sent you back. Greece is still responsible for your application. They still have to consider it. But the way it's been revised, I think, the effect of it is that Greece can, indeed must, treat your application as implicitly withdrawn. Germany sent you back. Greece cannot deal with it. It's not only a safe third country clause. No one is going to look at the substance of your asylum application. I think that is fundamentally problematic. It's not even, a safe third country argument. At least they deal with other countries that are looking at it. But no one is going to look at it. So that, I think, cannot be compatible with the EU Charter. And have someone challenge it and get to the courts to argue it. Right, now the new part on management of asylum. Well, there's meant to be, there's a lot of warm words about asylum management based on strategies of asylum management. One of these things is going to be dealt with more at EU level and a national policy sort of fitting within this broader EU strategy. Notice the first of these, all of these strategies. First one within 18 months, so before the main legislation applies, by the end of 2025. And the first of these EU migration strategies meant to have a prominent role for the case law of the Court of Justice and the European Court of Human Rights. And the lawyers will have a look at an argument about how much it actually does take account of that case law. There was meant to be an annual report on asylum and immigration, not just sort of, to be interesting and have a point of discussion, but to be the basis of proposing how member states help each other out in the Dublin process with the numbers of asylum seekers. So this is going to happen every October the 15th, starting next year. So again, starting before the deadline date, to apply everything, we're meant to have these annual reports starting and the solidarity pool already being set up and being revised every year. They have committed themselves to an annual argument every autumn. So as they had the year's fisheries in the budget, we will have it on numbers of asylum seekers. I'm sure everyone will be feeling very happy having had this discussion every autumn. So now this is crucially going to be a proposal from the Commission for a council measure. So the member states will ultimately adopt it. And I noticed the current Polish Prime Minister, Mr. Tusk, even with the new government there, said, well, we're going to stop this. Now, how can you stop it? Well, of course, they can stop it if, you don't have a veto, but if you get enough member states together, you can have a blocking minority. It's qualified majority vote. Enough member states together, it takes a number of member states in the east, if you get a couple more, they will have a blocking minority, and they can block something being adopted. So although the Commission has to propose at least 30,000 people being relocated every year and 600 million euros in financial contributions, that ratio must be maintained if you change it. Although the Commission has to propose that, the Council doesn't have to agree to that. The Council doesn't really have to do anything, it just block it. We're meant to have a solidarity pool every year, maybe we never get one. Or maybe, of course, it looks quite different from what the Commission proposed. But the Commission can propose more, it can't propose less, it can propose zero, strange enough, in exceptional situations. But the Council isn't bound to the 30,000, it can go up, it can go down, they can be agreed on zero. It will obviously depend on the votes within the Council having, going to be holding some very difficult discussion every year. And wildly, I think this is the one where the Commission proposal is, it's meant to be secret, I think. So that is it's kind of severe. Obviously, member states, they're not going to leak this. They're going to tell their press how they're fighting back against this ridiculous proposal. Either they don't want to take those people if you're Poland, or you want more to go if you're Italy or Greece. But the mere fact that it's secret is going to, you can see what the online discourse is going to be, right? It's all going to be about Bill Gates and black helicopters vaccinating everyone. These kind of conspiracy theories, they're going to be hugely induced by, white genocide and so on. And hugely encouraged by having this as a secret proposal. This idea that, you can have a nice civil discussion without so much public pressure, I think is naive and probably will backfire. But it is made absolutely clear, anyway, that member states have full discretion over whether to take people or not. Taking people is voluntary. Just as it is for resettlement, it's clearly voluntary within the European Union. Some of the language suggests that it's mandatory, some other language says it's clearly voluntary. So some of the debate that's been taking place has obviously been taking place on false pretenses. There was a whole referendum in Poland that took place under false pretenses at the same time as the last election which wasn't even a proposal, not even the final text. So that was weird. There's a whole debate that's going on in the UK on a false pretense. The government said that the Labour Party would opt into the EU scheme and take 100,000 people a year. Well, how would we be taking 100,000 people a year if the Commission proposal at least is going to be 30,000 a year? It's very unlikely to get up to 100,000 a year. Member states are not likely to agree to that. So, how can our share of 30,000 a year be 100,000? You can see why the Prime Minister thinks everyone should study maths to the age of 18 if that's how he thinks the mathematics of that will work. All right, you're done, very briefly. And if you're, probably no one here is, but if you are part of the broader security industrial complex, you might need a cold shower after this because it's a pure porn. It's absolute filth from the point of view of collecting massive amounts of personal data. So at the moment, Eurodac, already controversial, fingerprints all asylum seekers, all irregular border crosses, collects them in a databases, compares when someone applies for asylum. You can check but not score someone you find who's irregularly on the cherry. You see if they have applied for asylum, you might perhaps if somebody gets any increase, etc. on that basis. Now, what are they going to do? Well, they're going to massively expand the purposes. Asylum applying Dublin is, only one of many, many things it's trying to do. It's not just fingerprints, you can collect facial images. The age threshold drops from 14 to 6. It's for the people you're fingerprinting. It says you can use proportionate coercion against the children. There's some chilling drafting in this section. What exactly are they getting at? If you dislocate one shoulder, they've still got another one. What exactly are they thinking about this idea of proportionate coercion? It's now mandatory to store that data of irregular migrants. You collect it for more categories of people, resettlement cases, search and rescue, and future temporary protection. Not Ukrainians, we have another basis for collecting data on them, but future temporary protection. And for most cases, you store that data for far longer than it was stored at the moment. All right then, reception conditions. Again, speeding through this because I want to say the most about procedures. There are going to be limits on giving asylum seekers travel documents. There's some new grounds for detention, some revised grounds for detention. Still can't necessarily detain everyone, but there are lots of, the new grounds and the revised grounds to move in that direction, make it easier to detain people. The detention safeguard status still no time limit on asylum detention, except for orders of procedure cases, but that time limit is much longer now because the borders procedure is going from 4 weeks to 12 weeks. So yeah, there's a time limit, but there's a rather longer period that you can have someone subject to that procedure. We do have a time limit for judicial review and an actual practical remedy. If the court hasn't decided within the 21-day time limit, the person must be released. So it's a very genuinely effective remedy if Crime States comply. It's a genuine remedy. All right. Education is shorter periods of waiting. Employment, shorter waiting period, subject to the sanction if you're Dublinizing yourself, or subject to some exceptions if it's some accelerated procedures. But in principle, faster access to employment, more access to the job market. There's a lot of details on that. Okay, so asylum procedures. Now, there's a bit in the preamble of the asylum procedures regulation that says, we have dramatically simplified this. Everyone's a comedian. One type of special procedure has been dropped. All the others are vastly more complicated. And I'll summarize what the complications are. Now, a couple of important points here. The right to stay on the territory before your first instance decision is confirmed. That's still there. Crucial right, minor exceptions, but crucial right, obviously, for asylum seekers. There's more details on the start of the procedure. That was a crucial point which keeps getting litigated. It's very prominent in the existing procedures directive. Lots of case law which says you have the right to an effective access to asylum procedure. Now, they're trying to hide it. It's instead of being in Article 6 and very prominent, it's now in the middle of the regulation, in the middle of an article, in the middle of a sentence. As Douglas Adams might say, it's in a locked filing cabinet in a disused laboratory with a sign on the door saying, beware of the letter. But it is still there, and you can still argue. It's a very important case law on what it means. And I would argue, this is a general point about case law, and the paper discusses all the case law to date, how much of it is still in place, how much of it is still relevant. My argument is, well, it is still relevant unless there's a fundamental change in the text. And this isn't a fundamental change in the text. They've moved it around and so on. But it's still there. You still have a right of access to the procedure. Everything the court said, very important cases about access to the procedure, I think, should still apply. Now, there were loads of deadlines. I say they love deadlines and time limits. So 6 months in normal cases. You can still extend that, not quite as much as we could before. But there are more deadlines for other cases. We didn't have these before. So 2 months in cases of inadmissibility, some possible extensions. 3 months for other accelerated cases. The inadmissible cases are accelerated too, it's confusing. But accelerated on the merits, that's 3 months in those cases. Now, what's an inadmissible case? That's more or less the same. Part of it is mandatory, as it was before, where it's a repeat application with no new date. Some interesting case law on that should, I think, still be applicable. But the rest of it is still optional in admissibility. So it's one area that hasn't yet been fully harmonized, for example. But I won't go through all that. Some of general changes to procedure, the most important one, I think, is that member states must now issue a return decision either at the same time, in parallel, or integrated with an asylum decision. So at the same time they tell you, obviously you refuse, obviously if you're successful, this doesn't matter. But if you're refused, you must also be told at the same time you will leave. This is a return decision. It's not a separate process. It might come a few months later, member states might get to it some other time down the line, as they often do. No, this is very much an important part of member states' attempt to speed up, simplify, etc., the removals process. Borders procedures is going to be massive. I'll have to summarize it briefly. It's instead of an optional 4-week process, it's going to be largely mandatory 12-week process for people at the border. It's going to be a legal fiction, like screening process of pretending that you're not on the territory, even if you are. Although the impact of it being a legal fiction isn't as strong or as drastic as it might be, because the legislation says, even though we're going to say that you're not on the territory, so in principle, the law doesn't apply to you. Well, of course, you see a child anyway, and in fact, the legislation says that the rules on detention will still apply to you, and that the basic procedural rules, including the right to stay on the territory, even though you're not on the territory, will still apply to you. You can see why I think this is badly drafted in many places. Okay, now, there will be a 12-week deadline. Here, the 12-week deadline is for borders procedures, not just to decide on the application, but to deal with the appeal. So they're going to be deciding on the application even less than 12 weeks, and then the judges eventually acting very quickly after that. But in fact, the previous case law, and here's where keeping the previous case law is crucial. Previous case law says if judges don't run out of time to give a judgment by a deadline on asylum appeals, they can always have more time, right? It's not a real deadline. It's not a marking deadline. It's an academic monograph deadline, right? You can handle it as whatever they that we get to. All right, I can't go through all the border. I can't do much else because I do want to leave time for questions. But there are meant to be 30,000 people a quarter, so each of those 12-week periods, so 120,000 people a year dealt with by the borders procedure. The Commission will determine, in fact, I think this is one thing that happens quite quickly, it will determine how many each member state has to have. Even Ireland is going to have people in a borders procedure. Even member states which are like, with no external border, we're going to have borders procedures as well. Yeah, there it is. 2 months from now. Next week, the Commission must adopt the first of these allocation decisions. And there's details of exactly how it has to be covered. And now, if you're refused in that procedure, there's a separate borders return procedure, which is new, allowing you to be detained for another 12 weeks. And I think the whole logic of this borders procedure anyway is to make it easier to detain, because of course, once you say that someone is not legally on the territory, then any attempt they make to be on the territory under ECHR terms is a procedure to enter the territory, and that of course is one of the grounds for detention. Now there's a bit in the beginning, in the preamble, that says you don't actually have to detain people in the borders procedure. But that's like saying I could go to an ice cream parlor, buy 3 scoops of my favorite ice cream, and I don't actually have to eat it, right? I can watch it melt. But I'm not going to watch it melt. I mean, the only thing that's going to stop me eating it is the lack of capacity. And it's like the detention of cooking. The only thing that will stop all these people being detained will be, I think, the lack of any gap in capacity. Of course, you can challenge it on some of the general grounds. Remember, there is a ground to detain purely because you're subject to a border procedure, and purely after that because you're subject to a borders return procedure. Now, in addition to that, we have a whole load of accelerated procedures. These are now mandatory, so quite a lot of important ones there, including safe country of origin. That and many others are now mandatory. Or there's a new one, including there's a low recognition rate. That is now mandatory. What about safe countries? All very exciting. I want to have a chance to go through this in detail. But they have added a new concept of effective protection, which means that the state concerned that might still be safe doesn't have to ratify the Refugee Convention. Not only in Turkey not having and applying the geographical limitation, you don't even have to ratify the Refugee Convention to be a potentially safe third country. Okay, so first country of asylum, slightly revised text there. Safe third country, slightly revised definition of that. Bizarrely, you can target an individual. You can say, you personally are safe in Turkey, right, as well as groups of people, as well as parts of the country. Very odd thing to do, whatever they're thinking of. So that is a change. There's a change that definitely covered Turkey, which wasn't the case before, wasn't being applied before. But there are still safeguards. You can still challenge it in your individual circumstances. You still have to show a connection. The case law says transit is not a connection. Member states, I'm sure, are going to try and relitigate the case law. But the drafting of the preamble, the main text, does not say anything about transit now being sufficient connection. It says, if you're a family member there, that might be sufficient connection. So it's left open to argue whether that case law is still applicable or not. I'm sure that is something that people are going to argue. And that group of member states that want to change this, the legislation wants some agreements and use of this power very quickly. We'll see if they get that. One thing that you can do, same country of origin, very similar to what we had before as well. But one major change is that there can be even common lists of safe country of origin. You have to have legislation to do that. It can't just be the Commission deciding or whatever. However, to take countries out, and if you take a country out, a member state can't relist them for up to 2 years unless the Commission elects them. So quite significant there if you chop off a member state. It's a bit unclear how much of that is mandatory because some of it is inadmissibility, which isn't mandatory. All right, some major changes to appeal. Still lots of exceptions from suspensive effect. Now some deadlines, and I remember what the court said about judicial deadlines. It deals with a connection between return and asylum decisions. They must be appealed together, given that they are being issued together. There's a synchronicity between those two processes. Briefly, the crisis regulation, which defines 3 circumstances in which you can derogate, not from everything and not permanently, from EU legislation. So you can derogate from Dublin, the procedures regulation, everything else that applies, and the derogation has to be temporary. So only up until 1 year. The process, Commission, proposal to the Council, various extensions, but it can only be up to 1 year. And you can imagine member states saying, after 1 year has applied, well, let's have another year. That sort of argument has been rejected under the Schengen Borders Code, it's been tried under Returns Directive and Detention. I don't think it's a very good argument, but you can imagine it being made. The Commission's about to make it for temporary protection. The 3 years has run out, the Commission's about to say, oh, well, you can have another year. This may be sort of a degree of tension, not just with the member states, as I say, not applying EU legislation, but the EU institutions as well. Now, qualification regulation, most of the same text, some interesting further details, like internal flight alternative, exception to surplus, etc. And some exclusion parts, a lot of the details of the rights of individuals who are get status have been further harmonized. Just some final points of assessment. This isn't more liberal. It doesn't abolish the right to asylum either. Member states may go further than they're being allowed to do. You can't trust the Commission, as I have suggested. The Court of Justice may be crucial. It's already been, I know people at this conference don't think it's that liberal. People outside this conference do think it's liberal. That's why they're trying to overturn the case law and a load of points in the Pact. So whether to continue to be liberal, even ruling things invalid and capacity in EU law, I think is it's going to be a crucial question in how this works. There's a lot in here which is deeply contradictory. The Dublin system, for instance, which says we really want to make Dublin work, we really, really want to make sure people are in the member state where they're supposed to be, but at the same time says, oh my God, if everyone is in the member state where they're supposed to be, so we're going to overburden these member states, and then we've got to have a serious process of relieving, well, and have to both, right? I mean, you're trying to do these two contradictory things at the same time. In any event, so many people are going to be detained if you have the capacity with these additional grants that they may not be moving anyway if that goes ahead. There is a lot more harmonisation. Whether that works in deterring secondary movements, whether it even has to, whether they just rely on the sanctions for detention, is an interesting question. What are the human rights problems? Well, it doesn't abolish the right to asylum, but they've done a lot of stuff here, haven't they? They restricted the appeal rights for new areas where we don't have rights at all. Lots of deadlines that kids throw on asylum deadlines is messy. It says some of them are too short, some were okay. It's not quite clear how you transpose that to all the new deadlines that are going to be in EU law. I think it's going to be challenged a lot. There won't be much suspensive effect anyway, so it's going to be a lot of problems for the individuals concerned. There's a lot of defaults to non-refoulement. Okay, if you lose status, you can't apply, but you get non-refoulement anyway. So what does that mean? How many people are going to be in this kind of vague, rightless, mostly rightless, non-refoulement situations? And how much of these references back to basic standards are really, going to apply? Member states really going to look at a bit that says, oh yeah, you can have a fast track, but complying with basic standards. Member states are just going to do the fast track. To what extent really? Is this just going to be a rubber stamp? And member states will just say, okay, judges decide this within a week. Just say, yes, this is a big decision. We have this deadline. Just say that. They're gone. In practice, those standards won't be compliant. Okay, sorry that doesn't leave much time for discussion, but I did try and cover as much as I thought was crucial. So I'm happy now to take questions. I know some of you will have to leave, but thanks very much for listening.